Ladies and gentlemen, 680 days after the submission of the motion to dismiss, we finally have gotten a ruling from the semi-honorable Judge Maurice Hicks, Shreveport, Louisiana. Of course, it is not what we want, but just wanted to show everybody that doesn't know what this case is about. It's the U.S. Marshals. Brandon and I and Melanie Jerusalem have filed against the judge, the U.S. Marshals, and Walden Security, the private security firm that is contracted under the U.S. Marshals. So 318 days. This sign was up in the federal courthouse building in the Russell B. Long Federal Courthouse building in Baton Rouge, Louisiana. 318 days after the beginning of COVID, this sign was still up. It came down only the day that we filed our lawsuits against Judge Dick, the U.S. Marshals, and Walden Security. And it finally came down. But we have no resolution to our lawsuit. As you can imagine, Judge Hicks put this memorandum ruling in and dismissed all of our grievances with just chalking it up to judicial immunity. For the reasons set forth above, motion to dismiss filed by Chief Judge Dick and Walden Security are granted, and he made another order to dismiss the charges against the U.S. Marshals. So today we have ruined Judge Dick, Walden Security, and the U.S. Marshals Day, and we have filed a notice to appeal to the Fifth Circuit Court of Appeals. I can only hope that we get resolution in the 5th District. I am sharing this with you. For the people that don't know, the sign was up. They wouldn't let us in the court to even file papers because we didn't have a mask or we didn't have a vaccine. Eventually, the order came down that we needed to be followed around by an armed guard every time we came to the courthouse, which is intimidation and a violation of all kinds of things, of course, which we have all in our documents here. And so I wanted to share with y'all a letter that I wrote to the Louisiana Attorney General, trying to get her support and help in writing a amicus brief for our upcoming appellate brief. So I'll read this real quick to you. The subject is request for amicus brief in Fifth Circuit appeal, Brown versus United States Marshals, which actually it's Sibley versus Dick. I need to change that. I'm Dear Jordan, and I sent several requests way back when, and they got back to me and told me that this is the guy we need to be emailing. So I'm going to put his email down here below, and I would ask that each of you respectfully reach out to him and say that you've been following the case and you would like to see them file on the people's behalf to correct these injustices in the federal courthouse that's located right under his nose in Baton Rouge, just a half mile down from his office. I said, Dear Jordan, I'm writing to formally request that your office submit an amicus brief against Sibley versus Dick, which is now proceeding in the United States Court of Appeals, Fifth Circuit. This case originated in the United States District Court from the Middle District of Louisiana, case number 323 CB24. As pro se plaintiffs, we, Howard Brown, Brandon Sibley, and Melanie Jerusalem, challenged unconstitutional restrictions that denied us access to the Russell B. Long Federal Courthouse for over 3 years based on COVID-19 mask and vaccination mandates. Our claims include violations of the U.S. Constitution, federal statutes, and Louisiana law. Summary of the case. Our filings include an amended pleading, motion to clarify, motion for summary judgment, outline the following key issues: unconstitutional denial of access, the U.S. Marshals and Walden Security under administrative orders from Chief Judge Shelly D. Dick refused our entry into the federal courthouse without compliance with mask and vaccine mandates, infringing upon our rights under the 4th, 5th, 9th, and 14th Amendments. Privacy Act violations, defendants unlawfully demanded our private medical information as a condition for entry, violating the 1974 Act. And in the end, we had to be escorted by an armed guard to even enter the courthouse facility. Religious discrimination. We were denied access to a public facility based on our religious beliefs, violating federal protections and state constitutional provisions. Conspiracy and intimidation. Walton security personnel impersonated U.S. Marshals and engaged in intimidation tactics, including following us outside the courthouse while armed, and now following us around in the courthouse. Louisiana state law violations. The actions of the defendants contravene multiple provisions of the Louisiana Constitution and state laws, including Louisiana RS 14313, prohibiting forced masking, which actually is a felony to put a mask on and go in public in Louisiana unless you have a permit. So they have permits for Mardi Gras, they have permits for other things, but it's a felony. But yet the courthouse demanded it be procedure. And LA 14134, malfeasance in office. Despite clear legal grounds, the district court dismissed our claims, compelling us to escalate the matter to the Fifth Circuit. Given the significant constitutional and state law implications, we believe the Louisiana Attorney General's Office has a vested interest in ensuring the state laws and citizens' rights are upheld. Request for amicus curiae support. We respectfully request that the office file an amicus brief in support of our appeal. This case raises substantial questions about federal overreach, individual liberties, and the enforcement of Louisiana law in federal settings. Your support would help highlight the state's commitment to protecting its residents from unconstitutional mandates and administrative overreach. Please let us know if your office requires any additional information or documentation. We appreciate your time and consideration in this matter. I'm going to put his email address below and my email address below, and I would like you all to send him something in support, saying you've been watching this case and you're very interested in the outcome and you would really appreciate the Attorney General supporting us in this battle against unconstitutional activist federal judges. And I don't know that they'll be doing it, but I'm going to put our email address probably right here so that you can send them. Be respectful. Please don't say anything mean. This is this guy's business email address, and we don't want to flood his inbox with a bunch of nonsense. But we would like you to reference the case number that's going to be posted in documents that I'll link down below. And we hope that you will ask respectfully that he joins us in this battle against activist judges. So I've also reached out to U.S. Senator Kennedy, who's on the Judicial Committee. I've sent him a letter about this. And since the articles of impeachment seem to be back in popularity in the U.S. House of Representatives, I've contacted the Senate Judiciary Committee under the Whistleblower Act. Although their email my email got bounced back because their email address is full. I imagine they're taking a lot of requests at this time, but I'm going to continue. And I've emailed Cleo Fields, which is our representative here. I don't think any of y'all can email him because you have to go through and put your address in. You have to be a Louisiana resident, and you know that they have restrictions now on all the Congress emails to make sure you're a constituent before you can voice your opinion about a matter. But if I can find a relevant email address, I'll post it down below, and then maybe you can help with that. So we look forward to writing this appellate brief. A lot of it's already written. We just have to go through the process of cleaning it up and adding a few details that we haven't done yet. But just wanted to update you on the U.S. Marshals case, and that we are continuing the battle to the Fifth Circuit. And hopefully there'll be some common sense judges here. Maybe we'll take our side and grant us something, or maybe the DOJ now will get notice that this court case is going on, step in and settle the case or something, and agree not to do this again. But we want to file a preliminary injunction and try to get them to stop following us around with armed guards, and maybe even a blanket protection about this from happening again in the future. So Judge Maurice Hicks has deemed all those actions and our request for injunctions moot, because they could never imagine them requiring masks ever again. Oh no, that would never happen, right? Here's the update on the Marshals, and I appreciate all of you that would take the time to email Louisiana Attorney General and see if they will join us on this journey. Have a great day, and we'll catch you on the flip side.